Welcome back, everybody. So today we're on part 2 of the property series session, and the second part we're going to talk about how to sell or purchase a property that is owned by a minor, which means that this property is registered in the name of a minor. Now, how can a minor actually own property? You're probably asking yourself. Now, a number of parents in this day and age are starting to buy properties, particularly immovable properties, and are actually naming their minor children as the registered owners of those properties. And also, a minor can own property either by inheritance. So these are the two types of conditions, and also there are probably others, but these are the two that we'll focus on. Now, as much as parents are actually buying these properties and are naming their children as the owners of these properties, they are not quite aware, some of them that is, of some of the impediments that exist if you want to sell this property. And so today I want us to talk about this particular process. If you're a parent and you want to sell your child's property, this is the process you should be listening to, because it's not the usual process, because there's certain things that need to happen before that sale can get through. Okay, so if you're a person also considering to buy a property that is actually owned by a minor, you might want to listen as well, so that you understand exactly what the process actually entails. So for all of those that are actually new to the channel, welcome. My name is Yolanda Mnyengeza, and I'm an attorney and a director at Mnyengeza Attorneys. We trust that this video is going to be educational to you and prompt you to come back. If that is the case, make sure you subscribe, like, and share it to people that might use this particular video. So the first thing that you want to note is that property belonging to a minor in South Africa is protected by all means. Now, in terms of South African law, property that is owned by a minor, particularly an immovable property, cannot be sold just like that. People need to get permission either from the master of the High Court or the High Court itself, because the High Court is the upper guardian of minors. Now, you're probably thinking, why do I need to get consent from someone else? Now, these particular institutions that I spoke to you about, the Master of the High Court and the High Court, always look at the best interest of the children. And so you as the parent and the guardian may actually deviate at sometimes. Hence, there is this particular law that protects these children. Now, as I mentioned, in South Africa, you cannot just alienate this kind of property, even though you probably could say, but I bought this property, but then you registered it in the name of the minor, so it serves the interests of the minor. So if you want to sell it, there's a couple of things that you have to convince these two institutions, or either one of these institutions, and that is this: you selling this property is actually going to be to the advantage of this minor child. And number two, that you selling this property, you have a purpose. You want to use this money to serve something. Let's say the minor has an operation you cannot afford, and so you want to sell this house. So if you can show that this is for the benefit of this minor, it is to the advantage of the minor, and provide proof of this to the court or the Master of the High Court, then they will consider giving you the consent to sell that property. So what's the actual process you have to undergo in order for you to be able to sell this property? So the first thing that you need to do is to actually draft all of the necessary documents and send them either to the Master of the High Court or the High Court itself. So how are you going to know which department or institution to approach? So the institution and the department that you're going to approach will depend on the value of that particular property you're trying to sell. So if the value of the property is 250 and less, then you can go to the Master of the High Court to lodge a request to actually sell this property. Then they will consider that. However, if this particular property is valued at more than 250,000 Rand, you are going to have to make an application to the High Court, and then they will consider this particular matter on the basis that you provide all of the things that I spoke to, so that you can try to convince them, because failing which, they will not grant you that consent. Now, once you have then lodged either of these requests with either the Master of the High Court or the High Court itself, then you're going to have to wait a bit. And then if they approve it, they will give you proof in this regard so that you can be able to sell this property. This also applies with the High Court. You have to appear with your attorney or your advocate and then bake out your application. And the court, once they grant this, they will give you an order to this effect and they will allow you to sell the property. Not too difficult, is it? At least you understand where you need to start. So as much as these institutions may actually give you this consent that you're looking for to sell this house, bear in mind this one particular thing. Once this property has been sold, the money that is realized from this property unfortunately has to go to the government guardians fund. Now, we all know that a minor, if they have money of any sort, if it's not protected in a trust, it will be protected in the guardians fund. So in this instance, you will normally be requested to place all of the proceeds in the guardians fund and then request whatever fees that you need for whatever it is that you're trying to do with this amount of money. For instance, if you needed only 50,000 Rand out of the 200,000 Rand, the rest of the money is going to go to the guardians fund and it will remain there until the child turns 18 years of age. But what if you need something else as well during this process? I mean, if the 50,000 Rand finishes and it serves the purpose, can you then go back to the guardians fund? Definitely, yes, you can. You can make an application to the Guardians Fund, but you have to be a bit patient in this regard because the Guardians Fund deals with millions and millions of people. And so it means that you may have to be patient to get whatever funds that you need from the Guardians Fund. And also don't forget that in order for you to get access to funds in the Guardians Fund before the child is 18 years of age, you need to show that you really need it for the purposes of the minor and also to serve the minor's needs. So keep that in mind. Should you want to sell this property, make sure you have a think so that you understand exactly what you're getting into. So what kind of documents then do you need in addition to the regular documents when this sale has to go through? As mentioned, number one, we're going to have to get this consent as part of these documents. It also has to form part of the regular documents. Should we repeat the regular documents? Let's go ahead. The regular documents is that there must be a title deed in this particular transaction. Original title deed. If a person doesn't have an original title deed, for you as the buyer, you should be concerned and start asking them to try and get it, because this is a title deed that you need to reapply for at the deeds office should you have lost it. Okay, so in the meantime, however, they can provide you with a proof of ownership that is obtainable at the department or at the deeds office so that you can consider this particular sale. And another thing you should note about selling a property that belongs to a minor is that this particular property, unlike any other property, must be sold on market value and nothing less. Normally, I say try to negotiate with the seller if you feel that the property is not too up to standard, or if you have the opportunity. But in this particular instance, it's very difficult to negotiate this because it is required that this property be sold on its market value because it's a property owned by a child. Okay, so the second documents that you need, obviously the identity documents must be here. The contract itself must be here. So once these documents have been collected, and including the consent that you probably got from the Master of the High Court or the court order that you got from the High Court, all of this can then move ahead. The property transfer can happen in this instance. So always make sure, if you're a buyer, just assess first things first, who owns this property, so that you can understand what's the process going to be. Once you can master that, nothing can go wrong. But don't forget, as a buyer, always try to approach your own attorney to have a look at your own contract or the contract that's being offered so that you can see whether or not everything is in accordance, and then you can proceed with the sale. So this brings us to the end of our discussion today, and I hope that it was actually useful to you. And if it's not going to be useful today, sometime in the future it may be useful. And if you know anybody that can make use of this information, please again like and share it to them so that they can also get the education that you have received. And don't forget to come back because there's more content coming. And don't forget, next week we're talking about part 3 of this property series, and we're going to talk about how to buy property on auction, what to look out for, the terms and conditions, the do's and don'ts, so that you know exactly what you're doing when you're buying property on auction. On that note, this brings us to the end of our discussion. My name is Yolanda Mnyengeza, and I'm an attorney and a director at Mnyengeza Attorneys. Let's see you next time when we bring you something useful to you.